I'm really happy to have here today Dan Harris. I've seen Dan speak before on these issues, and I'm excited because I want to hear about how we're going to get the Chinese. Dan is the founding member of Harris & Moore, an international law boutique firm in Seattle. His practice focuses on assisting American companies with their overseas legal matters, and in particular in China and Russia. He's written extensively on doing business in China and has been quoted in every major publication: Wall Street Journal, Christian Science Monitor, Forbes, Business Week, National Law Journal, the ABA Journal, the Washington Post, and I'm hoping we'll hear a quote today about how the Chinese are going to pay. He's been engaged in international litigation, arbitration matters for most of his career, and typically has 4 or 5 cases pending in China. He's a co-author of the award-winning China Law blog, along with Steve Dickinson of Harris & Moore Lawyers. Well, and I'm very happy to have Dan here today. Thank you, Dan, for coming.
Thank you. With so many litigators in the room, I'm worried about the introduction Ryan gave where he said I was going to help everyone sue and win in China. I'm afraid
did I get that wrong? Sorry about that.
You got that wrong. The reality, I'm afraid, is very different. A clarification point today, I am going to be talking about only mainland China. I'm not going to be talking about Taiwan. I'm not going to be talking about Hong Kong. Some of you are probably thinking, well, why are you saying that? Because all the drywall comes from China, and so who cares about Hong Kong and Taiwan? And my answer to that is probably all the drywall was made in China, but it would not surprise me a bit if a lot of it was actually manufactured, or the owners of the manufacturing facilities in China actually are from Hong Kong or Taiwan. But I'm limiting my talk today to just China. At lunch, very pleasant lunch, a lawyer I was talking with kept asking me, she said, I need the answer to the big question. And the big question is, are we going to get any money from these Chinese companies? And my answer was, no, you're not. But before everybody leaves, I think it's a little more nuanced than that, and there are also some other issues beyond just collecting from the Chinese companies. With respect to that issue, the first question that I think that is the exact right question to ask. And the reason I think it's the right question to ask is because my firm has dealt with law firms that have sued Chinese companies and litigated against Chinese companies and spent years and hundreds of thousands of dollars doing so, and then they contact us and say, now that we've won, we'd like to hire you to collect on this judgment from China, take it over there and enforce it. And we have to say, no, it doesn't work that way. So it really is a question that needs to be addressed at the beginning. A couple years ago during the pet food scandal, or cases, there was a lawyer who was getting a lot of press, and he was talking about how he was going to make the Chinese companies pay, and he was going to sue them for this, and he was going to sue them for that. And he was based in a town very near where my daughter was attending college, so I called him up because I thought maybe we should talk, and I asked him how he was planning on collecting. And I thought maybe he had some theories to collect, and his answer was, I'm going to worry about that after we get the judgment. Well, you can't do that unless you don't care whether you're going to collect or not. The reality is Chinese courts do not enforce U.S. judgments. They do not. There's no international treaty, there's no bilateral treaty. No one's ever heard of a Chinese court enforcing a U.S. judgment. They don't like U.S. courts. They don't even really like the U.S. They're not going to enforce the judgment. So forget about that. Now, Chinese courts, however, will enforce a U.S. arbitration award, they'll enforce a Canadian arbitration award, they'll enforce a Hong Kong arbitration award. So I don't know how relevant arbitration is to these drywall cases, but it might be. So for instance, if you've got an importer that has, if you're representing an importer that has a contract with a Chinese manufacturer that calls for arbitrating disputes in Milwaukee, that's not so bad. because there's an international treaty, it's the New York Convention, I think from 1959, it's very old. Maybe it's not 1959, because I was going to say there are about 159 countries that have signed on to it, and if you read the list, you'd be hard-pressed to even notice a country that's not on there, because virtually every major country is on there, and China's one of them. So if you're going to be pursuing a Chinese company and your client has a contract that calls for arbitration, then go ahead and arbitrate, because if you win, then you can take that arbitration award to a Chinese court and you can enforce it. Now, there are definitely some limitations, and one of the most important ones is that, and it's the one that is most often missed, is that it cannot be an ad hoc arbitration. I'm coming from Seattle. Mediation and arbitration are huge in Seattle. It's the federal court requires mediation. Parties arbitrate all the time. It's been big there for a long time, and a lot of it is done ad hoc, where you just bring in some lawyer you know, and he acts as the arbitrator. That won't cut it. It has to be an established arbitral body for it to be enforced in China. So don't make that mistake. Okay, now once you've decided that maybe you can collect from a Chinese company, or maybe there are other reasons you want to sue them, and I'll talk about some of those reasons a little bit later, the first order of business is serving that Chinese company. Now, if you're going to be suing them in the United States, you need to serve them under the Hague Convention. That's what the U.S. is a party to the Hague Convention Treaty on Service of Process, and China is too. And so if you're going to comply with the technical requirements, you have to serve them under the Hague Convention. But the reality, like so many things, is somewhat different from the rule. And the reality is that a lot of times it doesn't matter. And I hate to say this, because I have fought with many courts here in the United States where my clients were not sued properly under the Hague Convention, and I've lost just about every time. It's actually kind of frustrating, because one of the rules that a lot of countries have under the Hague Convention is that your client must be served with the complaint and all the other initial documents in their language. So for instance, and China has that rule. So if you're going to sue a Chinese company here in the United States and serve them properly under the Hague Convention, you are supposed to translate the complaint into Chinese. Well, the problem is U.S. courts, and I'll talk more about the sort of different judicial view that U.S. courts have from Chinese courts. U.S. courts are not terribly enamored with service of process arguments. I mean, let's face it. And when you go in there and your client is represented by a reputable law firm, and you're claiming that the case should be thrown out because the complaint wasn't translated into Polish or Russian or Chinese or whatever, even though you're not disputing that you were served with it, the courts don't really care all that much. But at the same time, you might want to care, because you might be able to get away with it in the United States, but if you're going to take that judgment elsewhere, it might prove more difficult. But again, there are times where all you want to do is sue a foreign company. Sometimes all you want to do is get a default judgment against them with no plan of collecting. And in those circumstances, you can do what I call fake service. And my firm has done that many times against Russian companies, and 9 out of 10 times they don't show up. You get the default judgment, then you call them up, and then you start telling them what you're going to do with the judgment, even though there's not all that much you can do with it, and then they start talking about wanting to settle. One time we did this, and the Russian company came back with very good lawyers, actually it turned out to be a friend of mine, and argued that we hadn't served them properly, and there we were in federal court having to decide, do we make terrible arguments, or do we just cave and say, okay, we'll serve pursuant to the Hague Convention? We decided we would just say, okay, we will serve you pursuant to the Hague Convention. And the reason that can be so disastrous is because it takes so incredibly long. China, Russia, it can take 12 to 18 months. And that is not what you want to hear when you're the plaintiff. We were also involved in a case once where our Russian client was sued, and this gets to why do you want to sue a Chinese company when you can't, even if you get the judgment, you can't take it to China and do anything with it. Well, we were representing a Russian company that was sued in the United States and served, not pursuant to the Hague Convention, but they were served by fax, by email, by personal service, not disputed that they were served all these different ways. And the Russian company, allegedly, because it was my client, wrote a letter to the American plaintiff saying, look, we know you sued us, and we know we owe you $2 million, but we're not going to pay you, and you're not going to be able to collect it. So let's start talking. Well, the American company was too smart for our clients. They took the U.S. default judgment, and it took them about 4 or 5 months. They took the U.S. default judgment over to Korea, which does enforce U.S. judgments, and they seized our client's vessel right before it was to leave town. And all of a sudden, our client, who had not been our client until that point, started to care very much about the U.S. default judgment against it because it was going to be enforced in Korea. So we got a stay from the Korean court while my client's vessel remained under arrest, which was not a good thing. And we argued in Washington State Court that they hadn't been served properly under the Hague Convention. We lost on the lower court level, we lost it on the Court of Appeals. And the court did not like the fact that our client had essentially thumbed its nose at the American plaintiff, and I understand some of these drywall judges do not exactly like the Chinese companies thumbing their noses at the American courts, but the reality is that American courts' jurisdiction extends only so far, and that's really only to the border. Okay, these next few slides are going to deal with how to serve a Chinese company under the Hague's Service of Process rules. I'm going to push through these rather quickly. I'm not going to stand up here and describe how to do it. What I'll say, though, is it takes a long time. It's not very hard. You just follow the rules. It's not very hard. It's not very expensive. It costs something like $100 to pay some ministry in China to do it, and then they do it, but they take a long time. I read somewhere that there's a lawyer in these drywall cases who's talking about how it's cost him $25,000 to serve each Chinese manufacturer. I do not know how he's paying so much unless he's getting on an airplane and flying over to China and staying in 5-star hotels and serving them himself, because it's not that hard. But you do have to follow the rules because, like I said, if you don't follow the rules, it's not going to work. So these are just the rules, and you can find those right there at that website, exactly how to do it. But one of the things you do also need to do is you do need to translate your documents into Chinese, which also should not be terribly expensive, particularly if you use translators in China. And $100 payment. Another option is to not sue the Chinese manufacturers here in the United States, but to sue them in China. Now, I'm sure many of you believe that, that China doesn't have a court system, they don't have laws. They do, but in these circumstances, they're not going to help you all that much. One of the issues that my firm often faces is where an American company will enter into a contract with a Chinese company, and the American company will think, wow, I am going to write this